So again, our training today is brought to you by our partners over at the Workforce Development Board of Ventura County. And today we're so pleased to have Roxana Gamboa, the Business Solutions Specialist there, who's here to share more about the resources available to employers like you. Good morning, Roxana.
Good morning, Anna. Thank you so much for the introduction. And to everybody that's attending, thank you so much for participating. We appreciate you being here. And thank you for signing up. We at the Ventura County Workforce Development Board, we provide services for our local businesses in Ventura County at no cost. We provide information and services on sourcing and recruiting, job fairs, customized hiring events, including hiring events for at your location. And those are what we call targeted hiring events, and those have been very successful. We had one for Cal OSHA last month that had 100 participants that registered, and then 57 that attended the event the day of the event. So those have been very successful. We also have subsidized internships, information about work opportunity tax credit. We have the HR hotline that you see on your screen. We also provide financial solutions for employee training and no-cost webinars such as the one that you are attending today. And we, again, provide the services to our Ventura County businesses at no cost. We also have employer office hours where you can just come into our America's Job Center of California in Oxnard or Simi Valley. And we have open office hours for you to source and review candidates. And then if they're a good candidate, then you can have them apply for your organization. So reach out to us. Again, all the services that we offer are at no cost, including our job fairs. And Anna and Melody and Juliana, thank you so much for the introduction. And you will be having an amazing webinar, and we'll let you know when the recording is available. Thank you.
Excellent. Thank you, Roxana, for everything that you and your hardworking team do for so many employers and professionals in Ventura County. We love this partnership. So now I'd love to introduce our trainer today. We have Juliana Gabriel, our amazing Senior HR Compliance Director. So you are in wonderful hands. Good morning, Juliana.
Good morning, Anna. Thank you. And thank you to Roxana and Ventura County. I'd like to just take a minute to introduce California Employers Association, or CEA. We are an HR consulting company, and we have members located all throughout the state of California and well beyond California. And our focus is on providing you peace of mind with exceptional HR compliance solutions, training, and coaching. And we are also the voice behind that HR hotline. So when you are calling in, you are speaking with an HR advisor from California Employers Association. If you do find you need some additional support beyond the HR hotline, you can join us as a CEA member, and that would give you access to all of our resources. So we have hundreds of sample HR forms and policies and toolkits that can help you out in your day-to-day HR practice or as you run your business. And then we can also help you out with those HR projects. So whether you need a customized employee handbook, maybe you'd like us to conduct an I-9 audit for you, or general HR audit, or come out and do some training for your organization, we can help with all of those types of services. So you can visit our website at employers.org, and you're also welcome to call in to us directly with any questions that you might have. Now, I do want to remind you that this presentation today is for educational purposes only and should not be relied upon as legal advice. So CEA is not a law firm, and we're not giving you legal advice when you call in on that HR hotline or in these trainings. We're giving you best practices and general guidelines. So if you have an issue of legal significance, make sure you consult your own attorney about that. But that said, you're more than welcome to ask questions about the content. So you can go ahead and put those in the chat box, and I will monitor throughout the training and see if we can even answer some of those questions live. Or you're also welcome to follow up on the HR hotline with any questions that you might have. All right, so let's talk about what is on our agenda today. We have a jam-packed session. This has been a big year of updates, both on a state and federal level. So we're going to be talking about some increasing wages that went up mid-year in July. We have a lot of local minimum wage increases. And we also just had a brand new announcement from the IRS on increasing their mileage rate for employees engaged in business travel. So we'll talk about what that means in California. We're also going to give you some updates on OBA or HR1. So you might have heard references to no tax on tips or no tax on overtime. So we'll talk about that and what that means for you as an employer. We're also going to give you some updates on artificial intelligence. So what laws or regulations do we have in California for employers on that? And also, where might we be headed soon when it comes to AI regulation? We're going to refresh you on some of those annual notice and training obligations that might be coming due for you to make sure you're staying on top of that HR checklist. And then we'll close out with federal developments and some fun case law updates to go over. So jumping right into our wage and hour section now, let's just start with our 2026 minimum wage and salary amounts. So as a reminder, for your non-exempt hourly employees in California, their minimum wage is currently at $16.90 an hour. And you might have noticed that these minimum wages seem to just keep increasing every year, and there's a reason for that. Anytime inflation exceeds a certain amount in the consumer price index, there's these automatic bumps that happen. So I think we're likely to see another increase next year. And what some people don't realize is every time that minimum wage goes up, that exempt salary amount for our administrative, executive, and professional exemptions also goes up. So remember, to be properly classified as exempt, meaning that we don't have to worry about that employee's time tracking, overtime, meal and rest break, they have to meet both a duties test and a salary minimum. And that salary minimum is 2 times the state's minimum wage. And then you multiply that by 2080 hours a year to get the annual rate of $70,304. And you cannot prorate that. We'll have questions, what if I have a part-time salaried person? Can I prorate that? And the answer is no. That is the minimum to be properly classified as exempt. If you can't sustain that in your budget, you would want to classify somebody as a non-exempt hourly person. Now, in California, within the past few years, we also have these industry-specific minimum wages that have come about. So one of those is for fast food chains, for establishments with over 60 locations nationally. A lot of franchises fall under that. Their workers need to be at $20 an hour. And for the exempt salary amount at those fast food chains, it is $83,200 a year. In California, we also have many local minimum wage requirements on a city or local level. So let's jump into an example with that. I'm going to ask you a little quiz question here. How do we pay this person properly? Your headquarters is in Stockton, California, which follows the state's minimum wage of $16.90, or we could say in Ventura County, which follows the state's minimum wage. This week, your non-exempt employee worked 3 days in Stockton and then spent 2 working days at a conference in Oakland, which has a local minimum wage of $17.34. So what is owed here? I'm going to run a little poll. It's anonymous, so just give me your best guess. All right, so is it $16.90 an hour for the whole week because your headquarters is located in Stockton? Is it B, you must pay $17.34 because that is the highest rate? Or C, you can pay $16.90 an hour for the work performed in Stockton and $17.34 for the work performed in Oakland. So this just illustrates how some of these tricky local minimum wage issues can come up. So just give your best guess, and then we will share those results in just a minute, and I'll also give you the correct answer here. All right, thank you. I see those that participation coming in. I'm going to go ahead and share those results. So most of you selected C, and that is the correct answer. So as we're going to learn in just a minute, local minimum wages are based on where the employee is physically performing the work that day. And I can tell you, I talk to employers every month that assume that it's based on where their office or headquarters is located. So that's a common misconception. Now, B, you could go with B and just pick the highest rate if you don't want to have to track, well, where was our employee this day versus that day, and you want to kind of keep it administratively easier for you. You certainly could do that, but you don't have to. So C would be the correct answer here. So let's go ahead and talk about local minimum wages now. We have over 40 different local ordinances that may apply in California. And a lot of them are around the larger metropolitan areas, definitely around LA and San Diego, the Bay Areas. And it's not just minimum wage. Sometimes localities will come up with additional requirements regarding things like paid sick leave or predictive scheduling. So anytime you're sending employees to different sites, we're always going to want to look into those issues. That would be a great thing to use that HR hotline for, to clarify that. So again, the local minimum wage is based on where the employee is physically performing the work that day. So if you send them to a client site in LA, right, and they're performing work there, we have to pay LA's minimum wage. We'll talk about that in just a minute. Or an out-of-town conference in San Francisco. Also for our remote workers, our remote and hybrid workers, it is based again on where they're physically performing the work. So if their home resident is in a different city or locality than where your office is, you're going to want to look into that. And then also we recommend having a remote work agreement that specifically clarifies or authorizes where they're allowed to perform the work, at their home residence, so that they don't start just traveling all around and working remotely, and then you're maybe not paying them properly. So Ventura County itself does not have a local minimum wage requirement. But again, as I mentioned, if you're sending people into LA, we want to be aware of that. And a lot of these local minimum wages go up on January 1 each year. And then there's a good batch that go up July 1. So if you're a CA member, we do have a great fact sheet for you on all of the current local minimum wages. Or again, you can call into that HR hotline if you have a question about a certain locality. So here are the minimum wages that went up as of July 1 to be aware of. So in Northern California, we have Alameda, Berkeley, Emeryville, Fremont, Milpitas, and the city of San Francisco. And in Southern California, we have LA City. So they are at $18.42 an hour. Los Angeles County is at $18.47. And then Malibu, Pasadena, Santa Monica have their own as well. And then for the hotel industry, they often have in many cities their own local minimum wage requirements that are even higher than just kind of regular local minimum wages. And San Diego also has a new one this year for event centers and amusement parks. So make sure you're always looking into that and paying your hourly employees properly. This typically would not impact that exempt employee salary amount. So this is for your hourly non-exempt workers. We also have healthcare minimum wages in California. So just like fast food, this is one of those industry-specific minimum wages. And you may have heard about the SB 525. This is where this originated, with the legislature's goal that healthcare workers would eventually earn $25 an hour. And it was kind of prompted, I think, out of everything that happened with COVID and how hard they were working. So how this works is it went into effect in October of 2024, and it had set future increases to kind of eventually try to get people up to around $25 an hour. It does cover many, many healthcare facilities, such as hospitals, many residential settings, physician groups with 25 or more employees, 25 or more doctors, outpatient clinics, and more. And the interesting thing about the healthcare minimum wage is it actually applies to most employees at covered facilities. So it's not just the healthcare practitioners or the nurses, it's also administrative and clerical staff, the groundskeeper, the janitorial workers, right? So it's everyone at a covered establishment for the most part. Now, there's not just one set minimum wage. So there's different wage requirements that apply depending on the facility type. And a lot of those increased as of July 1. We had the mid-year increases come into effect. So they currently range anywhere from $19.28 to $25 an hour. A lot of people or facilities are at $23 an hour. So if you're not sure whether this might apply to you or which minimum wage applies, the Department of Industrial Relations has some really great FAQs. We have a link for you here to access those FAQs. And you can also call into us and we can kind of help walk you through that guidance. There's also a special salary calculation for exempt employees in the healthcare industry. It's 1.5 times their healthcare minimum wage or 2 times California's state minimum wage, whichever is greater, which means every time that minimum wage increases, you're going to have to do a calculation to see, are you still paying them enough to be properly classified as exempt? All right, and I have a big announcement for you here on the IRS mileage rate being increased. But first, I just want to talk to you about why this is relevant and what our obligations are when someone engages in business travel and they're using their personal vehicle beyond their normal commute. So we're not concerned with their normal commute to work, but let's say, once they get to work, we do send them out to a client site, or maybe we're sending our employees to an out-of-town conference and they're using their vehicle to drive there. What California Labor Code Section 2802 says is that we, the employer, are responsible to reimburse employees for all reasonable and necessary business costs, including when they use their personal vehicle for work. So basically, the cost of doing business falls on us, the employer, not the employee. And what our labor commissioner has said is it's not just the cost of gas that you need to reimburse. So a lot of the times an employer will assume, well, you can just give me your gas receipt and I'll reimburse that amount. Our California labor commissioner has said you also need to factor in things like the cost of maintaining insurance and wear and tear on the vehicle. And this goes for both exempt and non-exempt employees. They are entitled to reimbursement. So what our labor commissioner has said is that if you use the IRS mileage rate, it's going to be assumed that you have taken into account all of those factors. So of course, we recommend using the IRS mileage rate that employees, they let you know their business miles and then you compensate them at the IRS mileage rate. If you don't do that, the burden would be on you if they file a claim to show that you've reasonably compensated them. So where are we at with the IRS mileage rate? At the beginning of this year, we were at 72.5 cents per business mile traveled. And they had this kind of rare announcement. It doesn't happen often. And they decided to do a mid-year increase on that. So they announced it on July 13th, but they made it retroactive to July 1. And they increased it again to that 76 cents per business mile. And that was really, I think, just in response to the increase in gas and oil costs happening right now. So that is in effect for the rest of the year. So you're going to want to talk to whoever handles these expense reimbursements, your accountant, controller, right? Make sure that they are sufficiently reimbursing. Another just tip here or a reminder is for our non-exempt or hourly employees, any business travel beyond their normal commute is also compensable time, meaning on the clock time. So sometimes employers forget that. They'll do the mileage reimbursement for the wear and tear and the gas, but they forget that it's also on the clock time. So that employee should be clocking in for that business travel as well. So keep that in mind. All right, so now I want to give you a refresher on OBA or HR1, and then we'll talk about some of the updates that we've had in this area. But OBA, it was a federal law that was passed last year, and there's a lot of different components to it, also related to the federal budget and federal agencies. So I'm obviously not getting into all of that. I am getting into the portion that is really relevant to employers, and you might have heard phrases like no tax on tips or no tax on overtime, and kind of just wondering, what does that really mean, and how does that impact me as an employer? So what OBA did is it established above the line deductions for federal income tax for what's known as qualified tips and qualified overtime that apply to the 2025 through 2028 taxable years. So there's a lot of confusion about what OBA did. It did not create new exemptions from payroll taxes or change how you have to do your withholdings as an employer. Really, your obligation as the employer is to just report any qualified tips or qualified overtime earnings to your employees on their W-2s. And then once they have this information, when they go to file their taxes and work with their accountant, then they can claim those federal income tax deductions. So you as the employer, you really have a tracking and reporting obligation. That's what you need to focus on. And there are caps to this, so it's not really something you necessarily have to know. You can work with your accountant on it, and employees will work with their accountants. But for example, the deduction is capped at $12,500 for individual filers on that overtime earning, $25,000 for joint filers, and it phases out for higher income earners. But that's maybe a little more information than you even need to know. So let's now talk about the update to OBA that we've had recently. So the IRS came out with a regulation on what qualifies as tips and who qualifies to claim these tips. And so you as the employer need to know this, right? Because you're going to need to report if someone qualifies to make these deductions, you're going to need to report those qualified tips. And just kind of the gist of this is they didn't want everyone to start claiming that their income was tip income and try to get these deductions. They really only wanted it limited to those folks who historically have earned tips in their industry. So they actually came out with a list of 70 different occupations that qualify. I'm not going to read those to you and bore you with those details, but they do fall into generally 8 categories. And so I can go over some examples with you of employees that would be eligible. So in beverage and food service, right, that would be hostesses, waiters, bartenders, entertainment and events, our performers or musicians. Hospitality and guest services, so a lot of folks in the hotel industry, home services, would be things like landscaping, plumbers, electricians, personal services. They've listed event planners, babysitters, and others as examples. Personal appearance and wellness. So that would be people like massage therapists, cosmetologists, manicurists, recreation and instruction. So a tour guide, a golf caddy. And then finally, transportation and delivery. So that would be people involved in valet or rideshare or parking services. So I would recommend, if you're wondering whether your employees qualify, that you do go take a look at that list of 70 to see if their occupation is identified there. The other thing that they clarify is that tips must be paid voluntarily by the customer. They truly do need to be a tip. So, when you go out to a restaurant and there's an automatic service charge or automatic gratuity, the IRS says generally those do not qualify. And of course, the deduction is only available for tips actually reported on a W-2 or 1099. So it's also just a good time to give your employees a reminder for cash tips. The rule is that they have to report to you any cash tips that they receive that exceed $20 in a calendar month. So that rule has already been on the books, but it's maybe just good to make sure you're following that practices and giving your employees a reminder on that. Now, when it comes to qualified overtime, OBA does allow a deduction for those employees that earn weekly federal FLSA overtime. So as a reminder, on a federal level, if you have employees that work, non-exempt employees that work over 40 hours in a work week, once they exceed 40 hours, they are entitled to time and a half. So they get that overtime premium. And it's that premium portion, that half portion of time and a half, that they are allowed to claim as qualified overtime. The important thing to remember for California employers, or what makes this a little bit more complicated, is only that federal FLSA weekly overtime qualifies, not California's other specific overtime rules. So as a reminder, we also have daily overtime. So when they work over 8 hours in a workday, they kick into time and a half, or over 12 hours in a day, they kick into double time. And then we also have a special rule when somebody's working 7 consecutive days in a work week, that 7th day is at overtime. So those alone don't qualify. It's only that weekly overtime. So you're going to have to work with your payroll provider or your system to make sure that you have a way to basically filter or track just that premium pay on weekly overtime, because that is the only one that qualifies. So then when you go to issue W-2s, there is now a box on the W-2 where you can identify or report any qualified overtime and tip earnings. All right, and then the last wage and hour update that I want to go over with you is new meal and rest break ruling for some commercial drivers. So if you don't have any commercial drivers, you can kind of tune out this slide and just give your brain a little bit of a break to digest. But if you do have commercial drivers, this could be an important ruling for you. So there is what's known as the Federal Motor Carrier Safety Administration, and they regulate many commercial drivers that travel in interstate commerce and that meet certain size and weight requirements. And by interstate commerce, we're meaning that they are crossing state lines or, hauling cargo to or from another state. And the FMCSA has made arguments that commercial drivers that fall under their hours of service regulation and their rules regarding breaks, that they don't have to follow California's meal and rest break rules, that federal law preempts California's law on that, or trumps California's law on that. And the Ninth Circuit, a few years ago, I think it was in 2021, they said they agreed. They agreed with this interpretation for drivers of property carrying commercial motor vehicles, but they left the question open for drivers of passenger carrying commercial motor vehicles. And just recently this year, they said, yep, California also cannot enforce meal and rest break requirements for drivers of passenger carrying commercial motor vehicles that fall under these federal hours of service regulations, because they're driving interstate, meaning they're crossing state lines. As you can tell, that's a very nuanced explanation here. And so the takeaway is this ruling does not necessarily apply to all commercial drivers. We don't want to just assume, well, I have somebody on the road and they're maybe occasionally driving out of state, I don't have to worry about meal and rest break rules. That could be an extremely expensive mistake to make. But we do recommend consulting legal counsel about it if you think this might apply to you, because that could save, a lot of, additional compliance obligations that you wouldn't have to worry about if you do in fact qualify. So we do recommend getting a legal opinion on it if you think that that may apply to you. All right, so wrapping up our wage and hour to-dos, make sure that you are adjusting those pay rates or looking into those pay rates for local and industry increases when you are sending people, outside of your city or where your, headquarters is located. And then check for updated local minimum wage postings. So a lot of these local jurisdictions do require that you put a posting up on your wall with the local minimum wage requirement. So let's say that you frequently send workers to, the city of LA or LA County. You can go to those websites, find the local posting, and just print it and put it up on your wall. Also, you're going to want to determine which employees might receive qualified tips, if any. And, for many of us, they are going to receive probably qualified overtime that we do need to make sure that we're ready to report on W-2s. So work with your payroll provider now to make sure you have proper tracking for that, and you can filter out that California specific overtime reporting. All right, so now we're going to shift gears a little bit and focus on some of the artificial intelligence updates and the current laws or regulations that we have on the book right now for California employers. We're also going to go over some new case law with you, and then drafting an AI handbook policy. So you might, have an AI handbook policy already that maybe you're looking to improve, or maybe you have not put one together and it's something that you might want to consider. We're going to give you some best practices on that. The first thing that I really want to say here is we actually don't have a ton of laws and regulations right now for employers when it comes to their use of artificial intelligence, but I do think we're going to have a lot more regulation in the near future. There's already a lot of proposed bills for this upcoming legislative session around AI. So I think towards the end of this year and into early next year, we're going to have probably a ton of updates in this area. And I think this is just going to be, a huge emerging area in general, including for employers and for HR professionals. And one signal that this is already kind of happening is Governor Newsom recently issued an executive order where he has asked California agencies to kind of start researching and looking into how AI is impacting the overall economy and job displacement. So the EDD is now tracking that information. They actually have a tracker that you can go and take a look at. And then the other thing that Newsom requested is that the agencies give feedback on whether there should be advance notice requirements before AI layoffs under Cal Warn. So basically, it kind of in response to a lot of these large layoffs that we've seen at tech companies like Meta and Amazon and many others, California is now considering, well, do we want to make sure that workers have advance notice before these AI type layoffs happen? So again, we're likely to see a lot more in the near future, but let's focus now on kind of what regulation we have for California employers at the current moment. And I'm going to start with this poll question to kick it off. This will be relevant to our discussion. So I'm going to go ahead and launch this. All right, so does your company use AI tools to screen resumes or select candidates? And then I'll go ahead and share the results. I see those responses coming in. Thank you so much for your participation. It's always just nice to hear from our attendees and kind of just see where everybody is at in the community. All right, I'm going to go ahead and share these results. So it looks like the vast majority of you do not. 82% are not using these AI tools, but we do have a small minority here that are considering it or do, in fact, use these screening tools. And we are hearing that a lot more employers are starting to use screening tools where the AI tool filters through resumes, right, based on its algorithm and decides who's going to move forward in that interview process. I've also heard of AI avatars even conducting the initial interviews. So imagine, being interviewed by an AI avatar that looks like a human and sounds like a human, but is not. So as these technologies start to emerge, we also want to be aware of some of the compliance risks with using these technologies to make or inform our employment-related decisions. So let's talk about California's concern in this area and their Civil Rights Department regulations. So last year, the California Civil Rights Department issued regulations that are aimed at protecting against bias and discrimination when employers use these type of AI tools or what's known as an automated decision-making system to make employment-related decisions, such as who to hire. So that is really their concern, is that there may be bias in these algorithms or systems, right, that lead to discrimination. And this regulation protects both applicants and employees. It does not extend to independent contractors. But at a high level, really what it does is it clarifies that employers use these AI tools at their own risk. So they say, you will be responsible if that ADS or that AI tool ends up discriminating against, a certain group or protected class, whether that's intentional or not, right? That might not be your intention at all. But if that AI tool, for example, decides that it's going to remove women applicants from the applicant pool at a higher rate, or older workers from the applicant pool at a higher rate, right? It's not going to give them the same chance that it gives others. The employer could be liable for that, on the hook for that. So these regulations are already in effect. They are the law. They went into effect in October of 2025. So I'll expand on these for a little bit, but I also just want to define what is an automated decision-making system, or ADS. So that is any computational process that makes a decision or facilitates human decision-making, meaning it helps you make a decision, even if the AI is not the final decision maker. And it's not just AI, actually. It's through any one of these following. So it could be artificial intelligence, right? AI tools like ChatGPT or Copilot or Claude, or resume screening tools that use AI technology, but also machine learning, statistics, and other data processing techniques. So for example, let's say that you have a platform where your customers or your clients can rate their experience with your employees or give feedback on that. And then your system then ranks your employees or gives them a score based on that feedback. And then you use that to decide, who do we want to promote, or who do we want to maybe give a raise? If that factors into your decision, that is likely an automated decision-making system that you have to ensure doesn't have a discriminatory impact or a bias. So AI is just one type of technology that kind of falls under this larger ADS umbrella, but you'll kind of hear me refer to these terms interchangeably. So let's just now focus on the CRD regulation a bit more and some of the key highlights here. So again, they clarify that our Fair Employment and Housing Act, FEHA, that's the law that protects against harassment and discrimination, that it applies when employers use AI tools or ADS to assist them in making employment-related decisions, meaning you have to ensure it does not end up having a discriminatory impact. And it's involving any one of the following. So hiring is one of those, right? And I think this is the biggest category right now that I hear employers using these tools for. So resume screening or initial interviews, right? But also promotion. So for example, let's say you go over to ChatGPT and you upload your team's performance reviews and background, and you ask, who should I promote, right? So that would be an example of using an AI tool for that purpose. Deciding who to select for training programs or other opportunities, deciding how to compensate your employees, making termination decisions. So if you go over to that AI tool, maybe go over to Claude and you ask it, you put in information about policy violations or issues you're having with the employee, and you ask it for feedback on whether you can or should terminate that person, or who you should select for a layoff, right? Or any other term or condition of employment. You, the employer, are responsible if that ends up having a discriminatory impact. And we'll talk about a real case where this is already playing out. The other thing that the regulations clarify for us, they also remind us that computer-based tests, quizzes, games, and other assessments should be job-related and consistent with business necessity. And we really advise to be careful if you're using, quizzes or online assessments to measure skills or to decide who you want to hire. A lot of these types of tests usually are overbroad, and they're not just measuring job-related skills, and that can lead to discrimination claims. So let me give you an example of that. Let's say that you have a computer-based test for applicants, and one of the things that it's measuring is how quickly your applicant is answering the questions. And maybe that's not really required for their job, right? Answering questions quickly is not really one of the job related skills that they're going to need. And so that test then has the impact of maybe eliminating candidates with learning disabilities from the applicant pool because they're not able to answer as quickly due to that learning disability. They could potentially bring a discrimination claim for that, right? That your test is not really focused on job related criteria, that you're making it overbroad and it's having this impact of excluding candidates with a disability. So that's just one example of how some of these things can end up going wrong. Another reminder that they give us is that we cannot use these types of tools to inquire into criminal history before giving a conditional employment offer. And I don't think that's to anyone's surprise. We already have that rule in California that if you have 5 or more employees, that you can't look into criminal history or ask about criminal history of job applicants until you've given them that conditional employment offer. So this is basically just saying you can't use AI to get around that, right? You can't go hop over to ChatGPT and ask it to look up the criminal history of your applicant. And then finally, record retention requirements. So if you do use these types of tools to make employment related decisions, you have to hold on to those tools 4 years from the date you created them or the personnel action you took, whichever comes later. So I think this is also something really important to discuss with your management team or your HR team. Do we want to use these tools to make employment related decisions? Because then we have to hold on to those records and those could potentially be used against us later, right? In a lawsuit. So some additional risk areas when we're using these tools in that way. So here's a real world example of how this is already playing out and leading to potential liability. We have this federal Mobley versus Workday case, and the plaintiff Mobley applied to over 100 different positions on Workday's hiring platform, which uses this AI tool. So he was a job applicant. He applied to a bunch of different positions with different companies, but the AI tool he's alleging rejected him every single time and is disadvantaging him and other job seekers over 40 years old, that it's basically removing older workers from the applicant pool, which would violate the Age Discrimination in Employment Act. If that was on a California level, that would likely be an allegation that it violated FEHA, right? This lawsuit is now a collective action lawsuit, meaning that we have, hundreds or maybe even thousands of plaintiffs involved. And so it just gives us some insight into those real world risks of using these AI tools in recruitment or for making employment decisions that we might not know how those algorithms are working or what bias they may have. So just be cautious in that area. All right, my next question when it comes to AI for you is, do you have an AI policy in your employee handbook? So I'm going to go ahead and launch that poll now. Thank you for your participation, and then we'll share the results at where we're all at on that. All right, I see your responses coming in. And I know we did have an AI training with Ventura a little while ago, so some of you might have got around to doing that if you attended that training. I'm going to go ahead and end the poll and share results. So it looks like we're all kind of mixed here. We have yeses and nos. The biggest category is we're working on it. And that's good news to hear because we do recommend for most employers that you do probably consider adding an AI policy to your handbook. So, and the reason for that is for a lot of us, our employees are going online and they're accessing the internet, maybe for research or for job related projects. And so they might end up using AI. And if you don't kind of put any guardrails or parameters around that, then they're just left to kind of guess, right, what you might want them to do or not. And so that's why it's a really good idea to address it. Even though this is not a mandatory policy you have to have, we would definitely encourage it. So let's talk about some of the key components of an AI policy and what we would recommend. So first, I would just define what is artificial intelligence or a large language model, right? And I would just give some examples: ChatGPT, Microsoft Copilot, Gemini, so that they know exactly what you're talking about. What is allowed? So what are they allowed to use it for? So can they use it for research? Can they use it for drafting meeting agendas, for taking notes? There's that AI feature sometimes on virtual meetings if you're on Zoom where you can take notes on the meeting using AI. Are they allowed to do that, right? Are there restricted business uses where you don't want them? using these technologies. You might say, for our sales department, we don't want any contracts you to use AI to do that. You need to go through our legal department, right? Who is allowed? You don't have to authorize all employees to be able to use AI in their job. So you might identify certain roles where it makes sense or limit it to managers, for example. And then this one's really important. What can't go in? So define sensitive personnel and customer data, trade secrets, business documents, legal questions, right? The things that we might not want to get exposed, because especially if you're using a public tool like a ChatGPT, that's not saved on our own internal server, right? We don't know where that information is going. I've also heard recently that a lot of these models are learning from the data that's getting put in. So if you have trade secrets or business document information going in, we might not know, right, how AI is using that or taking that information. Work product, ensuring quality and accuracy of work, making sure employees know it's their responsibility to verify their information and sources. They can't just say, well, AI told me that was the answer, right? And then some other great catch-all, just reminder regarding policy violations that we can't use AI for harassment, deception, fraud, right? Creating, fake photos or information that would cause harm. Privacy and property rights, work generated by AI for business purposes is company property. Remind them of that, and that you reserve the right to monitor those AI systems if you've given them, a business email to use, or if they're using their work laptop. And then I also think it's a good idea to put an equal employment opportunity statement, just kind of in line with that Civil Rights Department regulation that we talked about, your commitment to not using AI in a discriminatory manner. And if you are a CEA member, we do have a customizable AI policy available under HR forms that has these sections in there. All right, so takeaways, audit, familiarize yourself with how AI may already be a part of your HR tools. If you're using it for resume screening or employment decisions, you would likely want to make an assessment on, is there bias or potential discrimination happening that would expose us to some risk? It's also a really good idea to incorporate human review of those AI processes, or from time to time audit how it is selecting resumes, what the criteria is. Consider how employees may be using AI in the workplace already right now, and a need for an AI policy to put some safeguards and parameters around that. If you do adopt a policy, I would also recommend doing some training on it and giving them some concrete examples of the things you don't want them doing, and then monitor those legal developments. As I mentioned, we're likely to have a lot more bills and regulations in California in the near future for employers. All right, so now I'm just going to spend a minute on refreshing you on some of your ongoing training obligations. So as a reminder, within the past couple years, most California employers now have a workplace violence prevention plan requirement, where you need to have, similar to your general injury and illness prevention plan, you need to have a plan that addresses the potential for workplace violence hazards and make sure that you're keeping up on that, right? That we're checking that our doors have locks, that we have emergency procedures, that we're able to notify employees in the event that there's a dangerous person on our premises, right? All of those kind of things. And part of that is also an annual staff training requirement. So the law says that we need to train our staff on workplace violence every single year. And a lot of people initially put their plan together in July or by July of 2024. So a lot of people do come due around the spring or the summertime to get that annual staff training done. And it does need to be by somebody who's knowledgeable in the employer's plan. And you do need to cover specific components related to your plan, right? Your emergency procedures, your protocol. So you can, get some of like those videos offline that are kind of just pre-recorded on workplace violence, but that really should only supplement your own training that you do. And then for harassment prevention training, as a reminder, that's due every 2 years if you have 5 or more employees. So if you trained in 2024, you're going to be coming due in 2026. So non-supervisors need to have 1 hour. Supervisors and above need to have 2 hours. And then we also have to give harassment prevention training at the time of hire. So for most new hires, that means that they need to be trained within 6 months of joining your organization. So make sure you're staying on top of that. We also have our labor law posters and notice requirements. So many of us already know that we have a number of different state and federal notices that we have to post in our workplace. And some of those carry fines if one of those agencies decides, if Cal OSHA decides to come visit your workplace and they look for, compliance issues, you can be fined for not having certain posters. So a lot of employers will have like an all-in-one labor law poster that has all of the state and federal notices. There's many organizations that offer that. We do offer that on our store if you need it. But we did want to call to your attention, there was an updated posting this year, Cal OSHA Safety and Health on the Job. They did a mid-year update in April. So what we're recommending for employers is that you just go and print this posting and just put it right next to your all-in-one labor law poster, so you're staying up to date. The federal EEOC Know Your Rights poster, that's another mandatory poster. We're watching this one. It's been marked as undergoing revision by the current administration. They're likely to change that poster, but they just haven't done so yet. So that is one we are monitoring. And then finally, it's important to remember, beyond those posting obligations, we also have notices that we have to distribute every year. And this list has been growing. So one of those is the Earned Income Tax Credit Notice. This is a standard notice that we need to issue to our employees just to notify them of potential earned income tax credits they might be eligible for. So it's a standard notice you can get offline, but you do need to send it out when you send out W-2s or 1099s for independent contractors. And then a second notice, that same notice needs to also be sent out in March every single year. So a lot of employers miss that one. So you can confer with whoever kind of handles, distributing the W-2s for you, make sure that they are also sending out that EITC notice. We also have some fairly new notices that have come about just kind of in the past couple years that you do need to distribute every single year, meaning we're actually giving it to our employees. One of those is the Workplace Know Your Rights notice from our labor commissioner that has information regarding constitutional rights, immigration-related rights, interactions with law enforcement, those kind of things. It also is required for new hires. So you're going to want to check your onboarding packets, make sure it's in there. Same thing with the survivor's right to time off or the crime victims notice from our civil rights department. That's also one that needs to go out every single year, so you can give it at the same time as you do these other notices, and it's also required for new hires. All right, so with our notice and training to-dos, make sure you're keeping those postings up to date. If you're using those all-in-one labor law posters, there's at least some postings that change every single year. Minimum wage is a big one that often changes. So you're going to want to make sure you're staying up to date on getting a new poster, distribute those annual notices, and make sure you are staying on top of those mandatory trainings. All right, so let's close out with some case law and federal development. It's always fun to jump into cases and see how California courts are thinking about issues. This first question has come up recently for California courts. When an employee complains about conduct that isn't actually illegal, do whistleblower protections apply? Meaning if they were retaliated or they were terminated, can they file, a wrongful termination or retaliation lawsuit against the employer if the conduct wasn't actually illegal, what they complained about? And in some circumstances, the answer is yes. So even when an employee is maybe mistaken about the law, as long as their belief was reasonable, they could still have a whistleblower claim. So what happened in this Contreras case, there was an employee that complained about unequal pay, that there was a pay disparity, that his coworkers were earning more than he was. And he believed that that was automatically a violation of the law. Now, what our law requires under Equal Pay Act and other laws is that it could potentially be a violation or discriminatory if there is a disparity based on a protected group, right? A racial disparity or based on ethnicity or gender, which wasn't the case here. So what happened is Contreras complained about that. The employer shortly thereafter terminated his employment. It looked like it was basically in response to the fact that he made a complaint. And then he turned around and sued, right? And brought this whistleblower claim. And so the employer argued, well, what we were doing, actually wasn't illegal, the underlying conduct that he complained about. And the court said, but his belief was reasonable. He came to you in good faith, right, with this concern. And then you turned around and terminated him. So this is just a reminder that even if their conduct or the concern that they're complaining about doesn't end up being unlawful or a policy violation, if you turn around and then retaliate against that person, now you could be looking at some potential liability. All right, next question has to do with reasonable accommodation. So if an employee never discloses that they have a disability, when is it going to be assumed that you knew about it as the employer and that you should have concluded that they had a disability, and therefore meaning you need to engage in the interactive process and look into reasonable accommodation? So we have this very interesting husband versus Target case that was issued recently. So what happened was there was this employee, his last name was Husband. He was working for Target and everything was kind of going fine with his employment. And then kind of out of nowhere, he started having this erratic behavior. So he was using profanity in the workplace. He was yelling at other employees. And then he started asking these disturbing questions from his supervisor. He asked his supervisor if the supervisor had ever killed any coworkers. And then he also made comments about inanimate objects laughing back at him. So Target was concerned. The supervisor even said, hey, you might want to speak with a mental, health or practitioner. And the employee never disclosed that he had bipolar disorder. So he didn't disclose that. Target ended up terminating his employment for violating their workplace violence policy and what they construed as threats. And it was only after that that they found out that he had bipolar disorder. And so he sued and said, you failed to reasonably accommodate me. And so Target argued, well, we didn't know that he had a disability, right? We were never informed. He didn't tell us. A third party didn't tell us. And it wasn't necessarily obvious. And the court actually agreed here. They said, there could be other explanations for this type of behavior. It could be drugs and alcohol causing it, prescribed medication, lack of sleep and stress. So they gave all these other reasons to basically say it couldn't be assumed, right, that Target knew that this person had a disability or medical condition that needed to be accommodated. But they said in other cases, if you have an employee that's having seizures, right, often, they might not need to tell you that they have a disability. You might need to assume that and offer them reasonable accommodation. So these cases are fun, but they're also very fact specific. So we don't want to read too much into them. But it is some good news for employers, right? There might be circumstances where if we're not informed of a disability or medical condition, we might not have a legal obligation triggered unless it's really obvious that that is what is definitely going on. All right, and then the last topic that I want to go over with you is I-9 form requirements. So let's start with this question. So we received a notice of inspection for our I-9 forms from ICE. We submitted our records, but just realized that many of our I-9 forms are missing the employee's date of birth or date of hire on the I-9 form. This isn't a big deal, right? So I'm going to ask you for your feedback, your best guess here. This is the last poll that I have for you today. So what do you think here? Do you think that this is a technical violation that you're going to be able to correct? Is it a substantive violation that would carry automatic fines? Or are these not considered a violation as long as the individual is actually authorized to work? So give me your best guess here, and then I'll share the results. Thank you for your participation. All right, I'm going to go ahead and end the poll and share the results. So majority of you said that it's a technical violation, and that used to be the correct answer, but it is now considered a substantive violation. So let's get into that and also what that means for an employer that's in this predicament. So in March of 2026, ICE kind of quietly changed its guidance to consider many violations to now be what is a substantive I-9 violation, which means that each violation, if they audit you and they catch these issues, can carry an automatic fine of $288 to $2,861 per violation. That means per issue. So imagine, especially if you have a larger workforce and your I-9s were completed in a sloppy manner, that's a lot of potential liability exposure. So here's what they added to the list. On the employee part, Section 1, if they fail to include their date of birth, if they didn't include their date of hire, if they are an immigrant authorized to work in the U.S., if they failed to complete their registration or USCIS number on the form, and missing date of when they completed Section 1 of the I-9 form. So those are all now substantive. And keep in mind, that's on the employee Section 1. So when you are working on it with employers and or employees and they're completing their I-9, you have to make sure that they are filling out all of those required fields properly, right? Because that liability could come back and fall on you if, for example, they didn't include their date of birth on the form. The employer section, failure to print the name and title of the employer or authorized rep who completed the I-9 form, the missing date of hire in the attestation portion of Section 2, or in the case of a rehire on Supplement B, failure to provide that date that you rehired them. So what we would recommend here, obviously the stakes are higher, if you are going to potentially, face an audit from ICE or an immigration agency, and they also are increasing those number of audits. So we would really recommend that you do your own internal I-9 audit and catch and correct these errors before you ever, get an audit or an immigration agency that's wanting to look at your I-9s, right? So the USCIS has guidance for us on how we can conduct our own internal audits and go back and correct these issues. The employee has to correct Section 1 issues. You, the employer, would have to correct Section 2 issues. But there is a process and a way that you can go about this and make sure that you are, limiting that potential exposure. So we also do just recommend I-9 audits kind of on a yearly basis, maybe more frequently if you're hiring all the time and you're having, a lot of new employees come in and you're completing these. We would really recommend that you're frequently conducting I-9 audits. All right, so wrapping up here, I know we covered a lot with you today. This slide I think is really helpful to just kind of put everything in a nutshell for you. So first, make sure you're auditing any local minimum wages that might apply where you're sending workers, and also for business expense reimbursements when employees are using their personal vehicle. Use that mileage rate from the IRS, that's 76 cents a mile. Ensure that you are prepared to report qualified tips and qualified overtime earnings on W-2s. Draft your artificial intelligence policy, right? Get a start on that. Roll that out, train your employees on what would be, restrictions or parameters around using AI for work purposes. And then audit, are you using AI for employment related decisions in hiring, right? Look into, do we have potential bias or discrimination that might be happening? Distribute those annual notices that we talked about. Make sure you get those on your checklist and that you are conducting workplace violence training every single year and harassment prevention training every single 2 years. And then audit those I-9 forms and monitor for legal developments. And a great way that you can do that, any employer can subscribe to CEA's blog at employers.org. And we are all the time, we're posting about HR updates so that you can stay in the know and you don't have to worry about tracking that information. It was really great training with all of you today. I want to give you a big thanks for your participation and remind you that if you do have HR questions, follow-up questions, you can reach us Monday through Friday from 8 to 5, and that is provided to you. That is complimentary from the Workforce Development Board of Ventura County. And I also really want to thank them for sponsoring this event today. So with that, we will wrap up and close out, and I'll let Anna take over here.
All right. Thank you, Juliana, man, it's amazing how much information you guys cover in such a short amount of time. So thank you for keeping that so clear and comprehensive for us. If you feel that you do need a little more support, a lot more support beyond what is so generously provided by our partners over at Ventura with that HR hotline, there are a few different options for you to consider here just at employers.org. We encourage you to reach out and think about what you might need. As I mentioned at the top of the hour, the way that we continue to help you is by hearing directly from you. So I'm dropping a link into the chat, or you can scan that QR code you see on there. Again, it's only 5 questions. It's very brief, but the feedback that you share with us in that 1 minute and 5 questions, we really do take to heart, and we do use that to shape what we offer and how we offer it. So we appreciate you taking the time at the end of today. And then if you are joining us for continuing education credits, those are on the screen and those will be in the chat box in just a moment. There we go. HRCI code 747741, SHRM code 26-SAZTV. That's a fun one. If you need some guidance on what to do with these codes, or for some reason run into a little trouble with redeeming them for your continuing education credit, please just always reach out. You can call that hotline through Ventura, or you can reach out at ceainfo@employers.org. We are more than happy to make sure that you get credit for joining in live and participating today. So I think that brings us to the end. Roxana, was there anything else that we need to have everyone keep in mind before we send them back out to their workday today?
Nope, I just want to thank everybody for attending today. And again, as Juliana and Anna mentioned, if you have any questions, feel free to reach out to the HR hotline for any HR related questions. I also have entered my information on the chat. And if you have any other questions, I will be more than happy to assist you answering any questions that you may have, or any business services that I may assist you with. We look forward to servicing you, and thank you for attending.
Awesome. So well said. And again, thank you for this continued partnership and then everything that you do for employers in your county. So again, thank you all for taking time out of your day to spend training live with us. Thank you for the couple extra minutes here at the end. Look for an email either from our team or for the Ventura team with that PDF of the slide deck if you were unable to download it, as well as the link to the next training. So with that, we'll see you all again in August for the next training. Thank you again for joining us. Have a great day. Cheers.